Okay, anybody coming on late?
Minister, member Paul will be on shortly, but I thought, oh, he's on now. Okay, sorry.
All right. Morning, member Paul. Welcome.
Good morning, Minister. You know, I did not expect to see you this morning.
Yeah, I'm glad you said that because you're going to see me for an hour.
You're very versatile. I thought you'd be in the throes of finalizing your response to me, but I see that you have able support.
Yes, no, I'm gonna actually leave at 11 o'clock because I have another pressing matter to finalize my sectoral, but I wanted to start because obviously we know the importance of this. This is super important and we want to get it to closure as quickly as possible. So okay. No other apologies for absence?
No, Chairman, didn't receive any.
Thanks so much. All right, so at our last meeting, we revisited sections 13 and 14 of the Act and spent a considerable length of time discussing the regime set up under section 13(6) for suspension and revocation of a license by the minister arising from a breach of an agreement between the licensee and the single buyer. Among the issues raised were these agreements were between two private parties, and although the minister was responsible for issuing the license as well as for suspending or revoking the license under section 13(6), the minister did not have access to the agreements and would have to write to the OUR to obtain same. Members found this to be an untenable situation which did not and does not exist in other jurisdictions. They felt that this should not have been allowed in the first place and were of the view that in addition to the minister, the parliament and the public had a right to access these agreements. Members opined that any concerns relating to the confidential clauses that might be contained in these agreements could be dealt with via the various mechanisms that exist to handle sensitive information. The ministry also agrees with the view expressed by some members of the committee that a policy direction was needed at this time to address this fundamental issue. There was also the question of whether the agreement between the licensee and the single buyer contained an express provision which clearly states that a breach of the agreement would constitute a breach of the license, so that all parties were aware that this would trigger the regime under section 13(6). Another question that arose was how the OUR was made aware of this, that there had been a breach of the agreement, so that it could notify the minister as required under section 14, in order that the regime under 13(6) could be triggered. It was suggested by one member that the OUR to be given more powers to be able to police these agreements. If it already had sufficient powers, should become more proactive in exercising those powers. Members also wanted further clarification and information from the OUR on the issues raised above. The amendment which it has proposed under 13(16) and its input generally on the matters discussed by the committee, since the OUR is an internal part of the process. The committee clerk was asked to write to the OUR inviting them to this meeting and all future meetings of the committee. This was done. Ms. Beckford, did you get a response in relation to who that person would be?
Yes, Chair. I see Mr. Cedric Wilson in the meeting.
Welcome, Mr. Wilson. Sorry that you have missed all of those other meetings, but it's never too late for a shower of rain. So
and Mr. Hewitt as well.
Mr. Hewitt.
Yes.
Excellent.
Yeah.
That shows,
a lot of us are here, Minister. Number of us.
Let me say to you, Mr. Hewitt, thank you very much for that, because obviously you realize, based on our concerns, the importance and for you to have been able to be here and lead your team is very, very commendable. We appreciate it.
Thanks, Minister.
The various issues relating to how the SEZs would be treated under the Electricity Act was also discussed at length, as it was felt that the current treatment of the investor developers in the SEZ could not continue as it was having a negative impact on investors and by extension on our country. This is something that Member Hilton has been raising in this committee and in Parliament and in every forum that he has gotten over the last many years. I received a letter from the JPS dated May 8th, 2023, specific to comments on the electricity supply within the SEZ on the sitting of April 20th, which I have asked to be circulated this morning so everybody can get a chance to read it. We may need to give you some time to digest it and come back, but we can always put this on the agenda. We can have a brief discussion on it, but give it a more time in terms of our next meeting to deal with some of what they have responded. Additionally, I had indicated at the last meeting that I expect to be able to provide further details at this meeting on the issue raised several meetings ago as to how developers who wanted to supply electricity exclusive with the SEZs and not the grid would be treated under the Act. So I think the JPS's response is timely on that. We ended our deliberations at section 18.9. Please note that no feedback was received from members concerning a proposal made by Mr. Simmons from the LRD as to whether the OUR's concern about section 18.6, 7, and 9 could be addressed by replacing the words supply of electricity with the words provision of electricity. So, as I said, we received the letter from JPS, and of course, I will get to the next proposed meeting, which is Thursday, 18th of May at 10 a.m. So I give members some time to look at their calendar so that at the end of the meeting, you will be able to advise whether or not. And let me just give you some dates from right now so that you can all check your diaries. And when we get to the adjournment, we'll be able to agree. So May 18th at 10 a.m., May 31st at 10 a.m., for which, unfortunately, I'll be off island, but I will have a chair elected at that meeting. And then Wednesday, June the 14th, 2023 at 10 a.m. So let me repeat those dates. Thursday, May 18th, 10 a.m. Wednesday, May 31st, 10 a.m. Wednesday, June 14th, 10 a.m. All right. I'll also defer the reading and confirmation of the minutes of the meeting held April 13, 2022 to allow for members to just go through that during this course of this discussion here, this meeting, and we can do it at the end. So at this point, I'm going to ask for the continuation of the discussion and the review of the matrix. Ms. Beckford, what is the thing? We're going to have the OUR first, or what? Or go to the matrix? What's the format?
Chair, it might be best to just tidy up with the OUR and then move on.
All right. So we invite the OUR. We invite the OUR to opine and then we'll go to the matrix. We'll go to the matrix. So, Mr. Hewitt and your team, you have the floor, sir.
Thanks, Chair, and morning members. I'm going to ask Ms. Shanae Riley to lead in terms of providing our response to the issues that have been raised, Minister. Thanks.
Good morning, everyone. I apologize, I was a little late coming in. Would it pertain to the letter that we got ending of April that had several queries in there? Is that where we
Sure.
Okay.
Sure. And anything else that we may want to contribute. So.
Okay, thank you, Minister. With regard to that letter, several queries were submitted to us. We have not been able to submit our responses in writing, which we will at the end of the day, but we'll go through them quickly. So based on the letter, we summarized one of the queries as follows. there was a query as to whether the license contained an express term or provision that a breach of the agreement between the licensee and the single buyer would constitute a breach of the license, or whether a breach of the agreement becomes a breach of the license simply because of section 13.6. And that arises from discussions with regard to a concern or a comment that we had made that it is only where there are license breaches that are unresolved as between the parties to a power purchase agreement that would then trigger a license breach. And so our response is that the generation licenses that we have seen that have been issued to IPPs since the promulgation of the Electricity Act actually do have express provisions that render breaches of the power purchase agreement as a ground for suspension or revocation of license. So those licenses do in fact make reference to that potential breach that is made mention of in the Electricity Act. The next query related to whether PPAs were reviewed and sanctioned by the OUR. Mention was made that the OUR was custodian of these agreements, and that there was concern that the minister had to write to the OUR in order to have sight of these agreements. The OUR, we are not custodian of the PPAs. However, we do have access to them because of the nature of our regulatory functions, one of which is the obligation to approve the terms and conditions of the PPAs. So in exercise of that function, naturally, we will have to have sight of the drafts of the PPAs and the final PPAs. There is also an express power in Section 10 of the Office of Utilities Regulation Act for the OUR to be able to request information from licensees pertaining to their operations. So in exercise of that power as well, we can request and gain access to various agreements, including their power purchase agreement. Our disclosure of information that we receive in exercise of our powers, however, is circumscribed by our obligation to maintain the secrecy of information. And this is set out in Section 5 of the OUR Act, and also to the extent that any of the information that we have falls under the exceptions to the Access to Information Act. So we do not readily share information except where we are permitted to under the ATI Act. It is our suggestion that MSET may wish to take legal advice in terms of its authority to be able to request information directly from its licensees. There is a possibility that MSET does in fact have this power, the minister has this power in light of the very broad planning and licensing functions that it has under the Electricity Act. And we did note that some of the generation licenses that have been issued to IPPs since the Electricity Act, in fact, have expressed provisions requiring licensees to provide information, reports, records as may be reasonably requested by the minister. So some of the licenses do in fact have that express power. So if there is in fact a constraint, an impediment to the minister or the minister being able to directly request information, one way of addressing this could be making it an express provision in licenses. Also under the Telecommunications Act, in terms of the provisions that relate to who the OUR is permitted to disclose information, including confidential information, there is an express provision in that act that permits the OUR to disclose information to the minister. So again, if there is in fact an impediment in law, that could be another possible option that the ministry could consider. Another issue is whether the OUR's proposal in respect of Section 13.6 was trying to cover those agreements that existed prior to 2015 when the Electricity Act was passed. So our comment that would have been submitted to the Joint Select Committee back in April 2021 arose from an acknowledgement of the strict nature of that statutory provision in the Electricity Act in establishing a license breach where there is a breach under PPA. And since such a breach could trigger suspension and revocation of an electricity license, there was a concern or the possibility that where such a contractual breach is resolved or somehow remedied as between the parties to the PPA, the commercial arrangements could then be frustrated if in fact the minister exercises his power to suspend or revoke the license. And so that was the underpinning of our suggestion that it is only in instances where the breach remains unresolved that could trigger, that final step. We never really had any comment regarding the application of this provision to older PPAs or older licenses that would have been in existence prior to 2015. It is noted, however, that if Parliament is minded to actually have this clause applicable to existing or PPAs and licenses in existence prior to 2015, then there is some language in the current Electricity Act that would have to be modified to allow for that. And these are the words, however, this subsection shall not apply to an existing license unless that existing license so provides. And under the Electricity Act, an existing license refers to those that existed prior to the Electricity Act. So there's an express exclusion of the clause in relation to those licenses. So if there is an intention of Parliament to have this provision applied, then that language would have to be modified. Another question, whether the OUR was being proactive enough in policing power purchase agreements. I ascertained that there was concern as to instances where the OUR saw blatant acts being committed by the parties under the PPA. There was a desire that the OUR should be able to indicate to the parties that their behavior was out of line, that their licenses should be suspended, instead of only being able to intervene when the parties disagree. So there are aspects of the PPA that are monitored by the OUR. Certainly we do get periodic reports in relation to some of the activities that are governed under the PPA. For example, we do verify payments that are made to the IPPs by JPS, because this has implications for JPS's tariff and the fees that are inevitably paid by the consumer. So we do merit that. There is also reporting that we receive to verify technical compliance. For example, we do examine generation dispatch, as well as scheduled maintenance requirements and periodic testing for validation of dependable capacity. So those are technical aspects as between JPS and the IPPs that we do monitor on a regular basis through the submission of regular reports to the OUR. But we do also acknowledge that there are other ways that matters do come to our attention. And certainly these would be triggered by events where there is some unplanned technical outages that often will trigger an investigation or inquiry on our part. We do receive complaints and concerns from consumers and also other stakeholders in the sector, and that often triggers inquiries. And also, as would have been mentioned and raised by the committee, where there are disputes between the parties, that is another trigger for us to inquire into the performance of the parties under the PPA. Also, from time to time, there are changes in the commercial, fiscal, and environmental environment that causes a relook at the provisions of the PPA. Often it has implications for the costs and the payments that are permitted under the PPA. And in those instances as well, the OUR will conduct its investigation and look into the performance of the parties under the PPA. So these are the means in which information will come to our attention as to whether or not we actually do need to take that ultimate action of triggering enforcement processes, which may eventually lead to suspension or recommendation for suspension or revocation being sent to the minister. We are quick to highlight, however, that certainly such a recommendation would be an act of very last resort, because as you can appreciate, pulling a generation licensee offline or the single buyer, because this also affects JPS if there is a suspension of JPS's license. One can only imagine the impact to availability and reliability of electricity. And so in instances, if a recommendation is made for suspension or revocation, that would really be in an egregious circumstance and a very last resort after we would have taken other regulatory steps, including discussions with the parties, issuing of orders, directives, memorandum, requiring remedial steps. Those would be the steps that we would take before ultimately going to the point of recommending suspension or revocation. There was also a question under Section 14 of the Electricity Act. Clarity was sought on whether the OUR had powers under the OUR Act to investigate and monitor licensees' compliance with provisions of their license, their codes, the Act, and any regulations made under the Act, and whether in undertaking the investigation, the OUR had powers to request information, to interview persons, to notify the licensee of any contravention, to request the licensee to provide justification, or direct the licensee to take remedial action, and whether or not these specific powers needed to be specified or replicated in the Electricity Act. So the quick question is, yes, the OUR does in fact have all of those powers under the OUR Act. Currently, the Electricity Act is not really a comprehensive or a standalone act with regard to the regulation of the Electricity Act, because a lot of the powers of the regulator with respect to the electricity sector are still derived from the OUR Act. And there are, in fact, provisions in the Electricity Act that specifically refer to the OUR Act as well. So all of the concerns or the queries as to the OUR's powers are addressed in the OUR Act. We do have an express power to make inquiries, to conduct investigations into the performance of licensees in respect of the prescribed utility services, and that would include their compliance with any statutory or license or other obligations that they may have. And these are set out in sections 4 and 8 of the OUR Act. We do have a power to give directions to licensees and to require them to take remedial measures. That would be under sections 4 and 9 of the OUR Act. And we also have power to require licensees to submit information to us as well as reports under section 10 of the Act. And several of these carry a criminal breach. They're considered an offense under the Act if there is non-compliance. Also, where the OUR decides to embark on a formal inquiry process under section 8 of the OUR Act, the third schedule of that Act specifies detailed powers of the OUR to summon witnesses, to administer oaths, to compel the production of documents, and a failure of persons to comply with those requisitions are also considered offenses of the Act and carry a very minuscule fine, but also potential incarceration up to 6 months in the resident magistrate's court if they do fail to comply. There was a question as to whether or not the OUR is authorized or required to allow the licensee to provide justification. So yes, also as a public body under administrative law, the OUR is required to observe the rules of natural justice and to allow persons affected by its decisions a right to be heard. So both in the statutory law and the common law, the OUR does have that requirement. But notwithstanding the existence of these powers under the OUR Act, we did express to Joint Select in its submission of April 2021 a desire that the Electricity Act be more comprehensive, that it should be practically a standalone act in terms of the regulation of the electricity sector, because we did recognize that quite often stakeholders may refer only to the Electricity Act, either not realizing that there are powers and provisions in the OUR Act that would also be applicable. And so we did make the recommendation that the powers of the regulator and the functions of the OUR in relation to the electricity sector be detailed in the Electricity Act, even though many of them are already in the OUR Act. And if it is not the desire of Parliament to pull all of the powers and functions of the OUR as specified in the OUR Act into the Electricity Act, the proposal was that at the very least, the rate setting powers of the OUR under the electricity sector be included in the Electricity Act, because there are provisions very specific to the electricity sector that have been included in the OUR Act by way of an amendment. And so we think it would be tidier to actually put that in the Electricity Act instead. And also the various powers that I would have referenced earlier in terms of our powers to require information, to do investigations and make inquiries, etc. Those aspects of the OUR Act to also be included in the Electricity Act, the power to issue directives and memoranda, etc. So those are responses to the queries raised in the committee's letter.
Thank you very much. I'm going to open the floor to members to respond if any clarifications or any comments based on. Thank you very much for that. You are very concise. Is there any member that would like to respond to the OUR's comments? Okay.
Chairman, I'm so sorry.
Yeah, I was wondering. I was giving you all the time in the world because I figured that you'll be the first one to jump on.
Well, I'm trying to get a copy of your speech for today, but nobody can give it to me.
You only have to ask me, you know. All you have to do is just say the word.
No, I thought that was a very good, comprehensive set of responses from the OUR. And I think that's why it is going to be very useful for the OUR to remain with us as we sit, because Council is quite correct. The 2015 law was really designed to deal with a particular situation that had emerged. And it wasn't supposed to be as comprehensive as our work, I believe, will lead to. And the law does rely a lot on the OUR Act, but as Council has said, it is probably better for us to have a standalone law that covers all aspects of regulation and to which investors can go to, rather than having to, not only investors, but stakeholders, rather than having two different bits of legislation. So I agree with that. And I have also taken the comments in relation to confidentiality as well. And she has pointed to the role of the minister, and that there was some leeway given in the 2015 law to enable the minister to extract information. The term was used that it was reasonable information, but you know, I suspect we might want to expand on that as we go forward. But yes, I believe that the presence of the OUR is very useful, and we need to ensure that for the remainder of our sessions, they are there just in case, you know.
I agree with you 100%, Member Paul. And I think it's better late than never. They should have been there from jump. It was an oversight, and we realized going through the matrix how important they are. So I'm going to ask the ministry reps to please take note of the responses and incorporate them accordingly, because I believe that we all have accepted their comments and recommendations. So I know Member Paulwell has spoken, and I haven't heard anybody else, so I take the silence as consent to my comments and Member Paulwell's comments. Is there anybody else that wants to have any input in that before we move on to the matrix? Okay. I'll turn over to the ministry. Ms. Campbell, Mr. Rob Richardson, please take note of what was said and the responses, and I suspect that we will get them in writing in due course. Ms. Campbell?
You will, Chair.
Turn over to you to continue the matrix. And again, thank you to the OUR for the quick response, and of course the comprehensive team that they've put together to join us.
Good morning, Minister, members, and colleagues on the call.
Not hearing you too well. You're a bit in and out, so just check your connection and make sure that you give us a loud voice.
Am I clear?
Yes, much better.
Okay. So today we're going to begin section 19 of the Act.
Excuse me, Ms. Campbell?
Yes,
Campbell? Right. Read the last comment of the OUR on section 18. I'm not clear from the discussion what the final decision is.
Section 18 or section 13?
Section 18,
Well,
where we ended last time.
So we ended at section 18, but we were to go back to section 13 because that's what the OUR comment was required for.
There was a comment about section 18, what, 6, 7, and 9, I think. I'm not, if you could go up to 18, but I'm not sure what the final decision was. It wasn't clear from the meeting. Right. So it wasn't clear what the decision of the committee was. This one here, 18, 6, 7, and 9. So it's not clear what the decision is.
Okay, so OUR was suggesting that 18, 6, 7, and 9, because they relate to wheeling arrangement, that they should be lumped as one provision. And we had no difficulty with that.
Okay, thank you.
Sure. Section 19 of the Electricity Act deals with the independent power producer. Now, we do not have a comment from stakeholders to the Joint Select Committee, but the ministry's recommendation in relation to this particular clause, the recommendations are as follows. The subsection 2 of section 19, which requires that the OUR approve the terms of the power purchase agreement to be entered into between the single buyer JPS and an independent power producer. The ministry is recommending to the committee that the OUR advises the minister within 3 months of the parties signing that agreement of the conclusion of the agreement. And we are also, well, it's not for the act, but the ministry's thought is that there should be an express provision in the agreement requiring a copy to be furnished to the minister. In relation to subsection 3 of section 19, the ministry is recommending that the reference to the chief electrical regulator be replaced with the government electrical regulator, that's the GER. So the current provision says that the single buyer shall not be obligated to connect an independent power producer's generated facility output to the system unless both the single buyer and the chief electrical regulator agree that the independent power producer's connection will not compromise the safety and protection of the system. So our recommendation is to replace chief electrical regulator with the government electrical regulator, and the GER for short has responsibility in relation to electrical installation and works, regulating electrical installation and works. Is the recommendation clear, Chair, and may I move on if they are accepted? Yeah. Section 20, procurement of new generating capacity. The comment that we have from the JPS, they're recommending that the Act should be amended to establish the GPE as a legal entity, clearly setting out its powers and functions with respect to the procurement of additional generating capacity to the grid. Also, a complete framework should be done outlining the terms of reference, the terms or tenure, technical competencies, qualifications, and composition of the GPE should be included in page 18 of 26 of the Act, or a schedule to the Act, to allow for a transparent procurement process controlled by persons having the requisite technical competence. So in relation to that, the ministry wishes to inform the committee that these considerations were taken into account before the commencement of this Joint Select Committee, and policy approval was given for the amendment to the Electricity Act to address those deficiencies that the JPS highlighted. And there is a draft bill, but we were advised to put it on hold because it's not appropriate to be amending the act while the committee is reviewing it. So the GPE would be set up as an entity, and there are provisions for its constitution and for its proceedings, and the type of skill sets that are to be appointed to the GPE. That is also stipulated in the bill that has been drafted but not yet completed. And it will provide for tenure, procedure at meetings, resignation, appointments, similar to an entity created by law with legal personality. The other recommendation provided by the JPS is that the act should also impose an obligation on GPE members and appointees to disclose conflict of interest, including those arising by virtue of close family and business relationships, a precise mechanism to address real and potential conflicts of interest by members and appointees, including grounds for disqualification and removal, should also be included. And I confirm that there is provision in the new, in the bill covering conflict of interest, disclosure, and the mechanisms to be followed in the event of any such occurrence. And further, the Public Bodies Management and Accountability Act, under which the GPE's operation would fall, also have provisions in relation to disclosure and conflict of interest. Should I move on, Chair? Okay. The JCC, the Jamaica Chamber of Commerce, provided a comment in relation to section 20, subsection 4, and it relates to the right of first refusal. The current provision stipulates that that subsection 5, subject to subsection 5, the right of first refusal shall comprise a single buyer being afforded first opportunity to replace its existing generating capacity in accordance with condition stated in the 3rd schedule. Now, the JCC specifically says that the Act purports at section 20, subsection 4, the concept of a single buyer, which reduces the opportunities for competition in sale of electricity and does not incentivize the single buyer to be efficient. The single buyer is afforded first opportunity to replace its existing generating capacity as the Act gives it the right of first refusal, an opportunity not afforded to any other generator on the system. This could lead eventually to the single buyer becoming the only generator, reducing the competitiveness of the entire generation to distribution of electricity process, thereby also reducing efficiency or disguising inefficiency. The response to this is that it is the policy that the single buyer model should remain, and the ROFA should also remain, because it is not only a provision or a right given in this Act, but is also embedded in the JPS license. And the ROFA is important to this grid stability, the operational efficiency that resides with the JPS, and it is considered that a sudden change may create uncertainty. So those are the reasons that the ministry would not agree with the JCC in either removing the ROFA or extending it to other IPPs. This might be more suitable for future consideration when the JPS license expires. The JCC also submitted a concern recommendation in relation to section 20, subsection 5. That section in the existing act states that the right of first refusal of a single buyer shall not be extended to any subsidiary company of the single buyer. Now the JCC is saying that the section 25, it does not extend the ROFA to subsidiaries of the single buyer, giving the semblance that the subsidiaries would be treated similarly to other generators. Then section 20, subsection 8, permits the replacement through a subsidiary. This is a clear conflict which needs to be addressed by the Act. Does it mean that as an IPP, the subsidiary will then have the ROFA whilst the other IPPs do not? The existence of a ROFA in the Act reduce competitiveness, generally, as it precludes other potential investors from bidding and more competitively priced generation being made available to replace the old units needed to be removed from the grid, thus eliminating the potential for consumers and industry to benefit from lower cost electricity. Now, having looked at the provisions, the two provisions, subsection 5 of section 20 states that the right of first refusal of the single buyer shall not be extended to any subsidiary of the single buyer. Subsection 8 states that the arrangement referred to, which is the exercise of the right of first refusal by the single buyer and the GPE, based on the rules established by the GPE, the subsection 8 says that the arrangement referred to in subsection 3 may, if approved by the GPE, permit the replacement of generation capacity through a subsidiary of the single buyer, provided that the legal and commercial terms and conditions of the power purchase agreement and other arrangements between the single buyer and the subsidiary shall be subject to the approval of the generation procurement entity. The challenge, as we understand it, that the JCC has is that although there is the subsection 5 expressly prohibits the subsidiary of a single buyer from exercising the right of first refusal, yet the single buyer may exercise its right of first refusal through a subsidiary on terms that the generation procurement entity permits. It is the view of the ministry that that subsection 5, which has the express prohibition, should remain. The JPS being allowed to exercise the right of first refusal through a subsidiary is not an allowance for the subsidiary to directly exercise the right of first refusal for the JPS in its capacity and in its capacity as a subsidiary, and which would be akin to an IPP. We believe that that subsection 5, which expressly prohibit that, should stand, and that the JPS being allowed where the circumstances arise to exercise it directly, but through its subsidiary, does not present a grave conflict in the Act. And as such, we do not agree with the concern expressed by the JCC and the recommendation. I'll move to the comment concern expressed by the OUR in relation to Section 20. The OUR says that as Section 20 deals with scenarios for the addition of significant generation capacity, it may be tidy to include specific provisions that address the addition of capacity from cogeneration facilities in this part of the Act. They make reference to Section 18, subsection 8, which merely mentions the power of the minister to prescribe the amount of capacity that can be added from these resources, meaning cogeneration facilities, but provides no details as to the process by which such proposal may be assessed. It is recommended, the OUR continues, that the minister's power to prescribe the amount of capacity that can be added from cogeneration facilities be removed from Section 18 and moved to Section 20 or placed in its own discrete provision. The ministry, in responding to this, based on our interpretation of subsection 8 of Section 18, it is a special approval that is given and not one given in the ordinary sense. We consider that the applications from cogeneration facilities to generate electricity would ordinarily go by the route of a generation application, or if necessary, be subject to if the consideration is to add additional capacity to the system, then the processes for competitive procurement be observed through the GPE. But based on our interpretation, Section 18 is a special circumstance, and we do not believe it should be added to Section 20. And therefore, it should remain. It may be placed in a discrete section, but it ought not to be relocated to Section 20. The OUR also has another recommendation that the cogeneration provision should detail the process by which such generation will be added and proposal assessed. Consultation and consideration of the recommendations of the regulator should be included in the minister's determination of the cap and assessment of proposals for addition to the capacity, for addition of capacity.
Sorry, Ms. Campbell, sorry to cut you. I have to leave. Is Member Miller still on?
Yes, sir, Chair.
All right, I'm going to ask you to take over for me. And also, just for good order, let's recall that the AG had said that the decision for the JC needed to be formally recorded after each clause. Our silence is consent, but just to confirm that we have we're in agreement with the clauses so far, and then ask that you take them after each clause. I completely forgot. It's important for the recording purposes. So before I leave, can I just ask for if there's any dissent on the clauses that we have gone through so far, and ask that we can confirm them. All right. So Ms. Campbell, Ms. Beckford, clauses so far are approved, confirmed, and Mr. Miller, there's no, Mr. Miller, Member Miller, I'm asking to take over if there's no objection. And please recall Mr. Miller that you have to take the minutes of the meeting of the 11th and confirm the dates for the continuation. And hopefully by the end of this, we should be in a position to be closer to the to being able to sum up. As you know, the cybercrime was done, so we wanted to conclude this one as quickly as possible based on the urgency. Thank you for your understanding, members. I have sectoral later, and I'm sure Member Paul will be there from 5 to 2. And all of the other MPs who are online here, who want more Wi-Fi, they'll be there at 1 to 2.
Yes, Minister, I'll be there on time.
All right, my brother. Thanks a lot. God bless you all. All right. Go ahead, Mr. Miller.
Thanks.
Sure, one that sound like a bribe.
Well, I know you will be there early as well, because the truth of the matter is that I know that you have some locations that you have eyed for some Wi-Fi, eh? All the best. Good.
As a team, thanks for the opportunity. I think I'll have around half an hour as well, because I have regulation meeting at the house at 12:30. So I think we'll try and see how fast we can push through what is on the agenda. All right, thanks very much. Can continue.
So in relation to OUR's recommendation that consultations of considerations in relation to section 18, subsection 8, their recommendations should be included in the minister's determination of the cap and the assessment of the proposal. The ministry has no objection, and the minister, in exercise of his discretion, would necessarily consult with the OUR, the technical team within the ministry, and the GPE where appropriate, and those technical and other advice would be brought to bear on the minister's decision in respect of any such request. That was just to round up OUR's first comment. In relation to section 20, subsection 8, and that provision empowers the GPE to determine the terms and conditions on which the single buyer may, through its subsidiary, exercise the right of first refusal. The OUR is saying that it is not clear whether the GPE's right to approve the power purchase agreement between the single buyer and its subsidiary under section 20, subsection 8 is in addition to the OUR's obligation to approve such agreements between the single buyer and the independent power producer. The single buyer's subsidiary would be in the position of an IPP in the scenario contemplated in section 20, subsection 8. This should be clarified, and it is recommended that the regulator's approval function in this situation be confirmed. Also, the GPE would benefit from the sector's the sector regulators' technical expertise and broad knowledge of the sector, and should be required to consult with the regulator prior to approving the exercise of JPS's right of first refusal through a subsidiary. It is recommended that the OUR's function of reviewing and approving the terms and conditions of the PPA in Section 19 of the Act be expressly applied to the approval of the agreement between the single buyer and its subsidiary contemplated in Section 20, subsection 8. Also, the decision to permit the exercise of JPS's right of first refusal through a subsidiary should be subject to the consultation with the office. The ministry has considered the OUR's proposal, and we have no objection to the OUR, the GPE consulting with OUR on the decision as to whether to allow the JPS to exercise the right of first refusal through its subsidiary, and for the GPE and the OUR to collaborate in approving the terms of the power purchase agreement where any such decision is taken. Should I move on, Chair?
Yes, go ahead, please. Are there any questions? Since there is no question, move ahead, please.
Thank you. The BMR Energy, they have submitted in relation to Section 20, subsection 3 of the Electricity Act. They have said that in relation to Section 20, subsection 3 and the third schedule, it is proposed that the right of first refusal provisions of the Electricity Act be deleted to assure that all future generation capacity, whether it is for thermal renewable storage or other technologies, be procured by the GPE through open, public, competitive bidding programs. Failing the removal of the right of first refusal provisions, it is proposed that the provisions are revised to 1. Apply to all other generators with facilities procured through the competitive bidding processes. 2. Require energy pricing offered to replacement projects be no higher than those that would be paid to projects of like type procured through competitive bidding processes. The ministry, in considering the proposal from BMR Energy, is recommending to the committee that the policy provision, which requires the retention of the single buyer and the right of first refusal right, be maintained, notwithstanding the concerns raised by the stakeholder. The right of first refusal is protected in the Electricity Act. It is also protected in the license granted pursuant to the Act to the Jamaica Public Service. And we do not consider that it should be removed at this time, but should be deferred perhaps when the comprehensive review of the electricity sector further to the impending expiration of the JPS license would be contemplated. The Private Sector Organization of Jamaica submitted their concern recommendation in relation to the said section 20 subsection 3. They're of the view that for section 20, the following are being proposed. In section 20 subsection 3, the protocols for capacity replacement under the ROFA should be amended to limit the single buyer from using the ROFA for capacity replacement using cumulative of multiple smaller systems. A lower capacity qualifying for ROFA should be established at 15 megawatts. The single buyer should not be allowed to compete in residential or commercial markets. So that's in relation to section 20, subsection 3. So the response that was given to the previous comments in relation to maintaining the right of first refusal and the policy for the single buyer to remain as the sole operator of the grid, and also the rights conferred by their license. On the basis of those considerations, the recommendation and concern in relation to section 20 subsection 3 given by the PBCJ could not be countenanced. In relation to section 20 subsection 8, they have also proposed that that provision is removed, and for the reasons already mentioned, and also in light of the fact that the GPE will consider whether or not it's, well, and in consultation with the OUR now, that those entities will consider whether or not the right of first refusal may be done through the JPS's subsidiary. We believe that there would be enough, the proper considerations given, and to ensure that any such consideration is taken with the best advice available and executed accordingly. Moving to the next recommendation, comment, concern, and this one comes from JPS in relation to section 20 subsection 7. They are of the view that in section 20 subsection 7, to provide certainty in relation to the procurement process, it is being proposed that the rules and protocols to be developed by the GPE should be included in a schedule to the Act and must also benefit from policy assessment carried out to enable the current review exercise. The rules and protocols, like the Act, should also benefit from periodic review to ensure that it is relevant and current. Now, in our considerations, the GPE, although not specifically stated here, but their rules and protocols that they develop will be reviewed over time. We consider that it might not be necessary to place them in a schedule to the Act, but that they may be gazetted by an order of the minister, and that provision is given for the rules and protocols to be updated from time to time. Further, to support transparency, predictability, and orderly planning development activities, we recommend that the Act specify the time by which the notification letter is to be sent to allow for orderly planning and development activities. We recommend a minimum 6 years prior to the scheduled retirement date of the asset. Now, by way of background for those who are not familiar, the JPS, there is what is called a schedule, a retirement schedule that is managed by the minister. And the retirement schedule consists of the assets, the generation assets of the JPS, and it has the dates for their retirement. Now, by way of process, as outlined more clearly in the third schedule to this Act, there is a notification letter that the minister sends to JPS indicating that a particular generation set, wherever it is located, is at or nearing the end of its useful life and it ought to be retired at a certain time. The JPS would now forward information on its proposal to retire that generation set, and that will be considered by the ministry in terms of procurement and other important considerations. Now, the JPS is asking that that letter be issued a minimum of 6 years prior to the scheduled retirement date for any of the assets. The ministry has considered and supports a fixed timeline of every 4 years, and this would be in line with the system planning integrated resource planning process, because the integrated resource planning takes a full picture of the sector and the capacities which are connected to the system and the determinations to follow. So we are of the view that 4 years is sufficient because the IRP is updated every 2 years, and on that basis, there would be sufficient information that would allow for the minister to properly issue a notification letter every 4 years. The ministry, as part of the IRP process, should publish the methodology for the determination of the avoided cost of generation that will form the basis for biannual updates. The methodology for the determination of the generation cost is published in the integrated resource plan, and this plan is updated every 2 years. The third proposal consideration is that for the inclusion of a provision for the GPE to table a report to Parliament within a specified period, setting out the reasons for a capacity procurement decision. In consideration of this proposal, it is not necessary we submit for a report to be given to Parliament. The GPE, as part of its accountability processes, would necessarily issue the report guiding any decision taken in relation to the procurement of new or additional capacity to the system. And that report would be available if JPS or any other person is interested in accessing. So that is a comment for the response of the ministry in relation to the JPS comments regarding Section 20, subsection 7. Chair, if there are no comments or questions or objections, please indicate so I may move on to the other
Any questions, guys? At the time, and I stated earlier that I'd want to leave by 11:30 because of a meeting at Parliament.
Okay, so if I may just conclude the last comment for section 20, and then you can take your decision, Chair. If I may be allowed.
Hello? Sorry about that. I lost connectivity a short while ago. So I'd want to pause there for now until the date of the next meeting that we will decide. Since Member Jackson and Paul Well would want to be early at Parliament today to
Chair, Ms. Campbell wants to conclude. Just give her the opportunity to conclude, and then she can start afresh at the next meeting.
All right. How long do you think it will take, Ms. Campbell?
Just a few minutes. It's the last comment for section 20, and that would conclude section 20 proper.
All right, no problem. Go ahead, please. Thanks, Member Ahmed.
Thank you. The JPS is proposing that section 20, subsection 5 be deleted, resulting in the exercise of the right of first refusal through a subsidiary under section 20, subsection 8. We're of the view, according to JPS, that section 20, subsection 5 may lead to a misinterpretation that section 20, subsection 8 adequately captures the intent of the section. So section 20, subsection 5 expressly prohibits a subsidiary of the single buyer from exercising the right of first refusal in relation to the retirement of the parent company, JPS's generation set. However, section 20, subsection 8 allows the JPS, where it has indicated that it will exercise its right of first refusal, and it will do so through a subsidiary, to be able to do so based on the considerations given by the generation procurement entity. And now, as the committee have accepted, then the OUR would be consulted expressly. The ministry does not accept the JPS's comment that it should be deleted. The express prohibition in section 20, subsection 5 should remain, and there are safeguards in section 20, subsection 8, and further to the consideration that will be given by the GPE and the OUR in allowing the JPS to exercise the right of first refusal. And as such, we do not agree with the recommendations that they have provided. That is the end of the response here.
All right, are there any questions? I've heard the comprehensive recommendations, and I guess everyone is in favor. Do what was said by Ms. Campbell.
Chair, may I ask a question before we go?
Sure, go ahead, please.
Once because the committee has signed off on these paragraphs, these recommendations, is there any further provision for comments, or that closes the process?
Well, I'm guided. I think that deliberation went a couple weeks ago in terms of the agents that came in and as committee. So maybe in terms of comments that you think might enhance, it's up to the committee to decide whether, that can be accommodated.
Thanks, Chair.
Okay. Are there any other questions?
Yeah, just to comment, and let me. Yeah, just to comment.
Go ahead, please.
With regards to, I think why. Are you hearing me?
Yes, sir, Wilson. Go ahead, please.
Yeah, just to comment, I think we do have some additional thoughts about the ROFA, which we think might be important in terms of the rate base and JPS exercise in the ROFA. The question that we haven't addressed, and I think it is important, if whether or not in exercising its ROFA and getting approval to do the ROFA, whether the new plant should be a subsidiary or it should be a part of the existing JPS rate base. I think that is a critical question, and we might have overlooked it before, but I think we stand to do ourselves some harm if it is not properly explored.
Okay, all right, I think that's a valid point. What are the views of the committee members? As I've always said that I'm in a learning stage. I won't boast that I'm competent in this area, but I'm learning myself. So in terms of the strategic decisions that needs to be taken, I would not believe that it's in my capacity to do so. So I'll take guidance from the community members as well.
I believe it can be deferred for further consideration, Chair. As you said, I think it is integral that we look into it properly. So maybe at the next meeting, it can be taken.
All right, so say everyone. Thanks, Member Hamilton. So say everyone.
Yes, Chair.
All right, thank you. So we'll defer that, Sir Wilson, for the next meeting when the chairman is here.
Much, Chair.
Sure. Thank you. All right, thanks again, Ms. Campbell. Yes, sorry. Someone tried to say something?
I was just agreeing with the chairman.
Okay, thanks, Member Green. Thanks for that. All right, approving the minutes of the last meeting. And I assume that everyone read that minutes for the meeting. Is there, let me look at it. Give me a minute, please. All right, the minutes held on Wednesday, April 13th. I assume that is there a motion to accept the minutes?
Chair.
Can you indicate by raising a hand?
Chair, I seconded the
Awesome,
motion.
thanks.